Hello and welcome to this conversation with Saul Marine of Saul Marine and Company Solicitors. My name is Nishit Kotak from Strategic Web Success. And today we are in conversation with Saul, who is one of our clients. And I'd like to introduce you all to Saul. Saul, welcome to today's call.
Thank you very much, Nishit.
Brilliant. So Saul is a solicitor based in Mill Hill in London, and they specialize in property litigation and property law. And today I'd like to share some highlights with Saul on one of the specialist areas that he is very, very good at, which is boundary claims and trespass from extensions or fences. So Saul, why don't you introduce yourself to the viewers today?
Okay, thank you, Nishit. So I'm Saul Marine. I'm the principal of the practice of Saul Marine and Co Solicitors. And as Nishit says, we specialize in property litigation, boundary disputes, and trespass cases, and problems with bad neighbors, basically.
Wonderful. So, Saul, this kind of thing is quite common. And one of the important questions people ask is, what are the kind of papers that are needed to be put in place before they come to a solicitor to ask for advice? What kind of evidence would we need?
Okay, so Nishit, one of the things that is really important is to try and get hold of the old deeds in relation to the property, because in those deeds there will be a plan of the boundary of the property, and also it may state who is responsible for maintenance of the boundary. So although the land registry do keep a lot of these documents as certified copies, so we can actually obtain that. But if you've got the old deeds, they would be really useful for us to have a look at to determine where a boundary of the property lies.
Amazing. So what are the important facts that are needed to support a claim about, a boundary or trespass?
So important factors are, for example, how long has the existing boundary been in position? And also who has maintained the boundary. But for example, if you've maintained the boundary, then you would probably know where the old boundary was that has been interfered with by the neighbour. So the looking at the position on site is very important to try and work out where the old boundary lies if there's been an actual encroachment. And also we do, as a matter of practice, actually go down to the site to actually have a look at the existing boundary and have a look at the issues that have actually become involved in the client's case. So a visit to site is very important to actually try and ascertain where the boundary actually lies. We find that when extensions are done, that is when old fences are moved, and that's when an extension can go over the boundary line and create a problem for the client.
Fabulous. So, people are very possessive about property, and rightly so. But in the UK, they are extremely possessive about property, and they don't want to give away an inch of the property, of course.
Yeah.
So whenever these kind of issues happen, like an extension, etc., it is more than likely that there will be disputes coming about where the boundary lies, right? So what is the right procedure to follow before a claim is started or defended?
Okay, so that's a really good question. So the most important point is to put the complaint that you've got against your neighbour in writing. So as solicitors, we are encouraged to put arguments in writing to make sure that the other neighbour understands what you're actually saying and what you want out of the situation. And we normally give some time for the neighbour to respond, 14 to 21 days with their sort of response on the case. And we also say in this initial letter that we would look at possible means of settlement, either mediation or some form of meeting that we can do to try and resolve the situation. And one of the skills I also have as a civil mediator is knowing when it is appropriate to have a mediation to try and resolve the dispute. Of course, as a mediator, I'm not acting as a mediator between my client and the neighbour, because I'm acting for the neighbour, I'm acting for my client as their solicitor. But using mediation skills is a way to actually try and resolve issues before you go to court.
I suppose that is step one of anything, because you're going to be staying with your neighbor for a bit of time,
Yeah.
and you want to maintain cordial relationships with them. So it is in the interest of both of you to resolve it in an amicable way.
Absolutely.
And also it is the cheapest way to do it in terms of cost, I suppose, because the cost of going to court, depending on the level at which you now proceed. I know there are several steps you can go and take forward to court, which brings me to my final question for you today, which is, how long does it take for a claim to be brought to court? And then what happens there? What are the next steps?
Okay, so if the initial letter hasn't created a resolution of the case, and the neighbour's not yielding and is not agreeing, then we would have to issue a claim in the court. Generally speaking, from the date of issue of the claim up until a hearing, you could be waiting for something between, say, 6 to 9 months. That is going to depend on, obviously, the timetables of the courts. At the moment, the courts are operating many hearings remotely, but we're hoping that with the relaxation of COVID rules, there's going to be more face-to-face hearings. But generally speaking, we could say between 6 to 9 months would be an approximate timetable, an approximate idea of when you might want to get to a hearing. Now, even if you've issued proceedings, it doesn't mean that you can't try and settle the matter, try and resolve it. You've always got those options open to you, but once the court timetable starts, there will be different issues that you need to comply with, filing statements and documents, etc. But generally speaking, you can be looking between 6 and 9 months, effectively.
Okay, so Saul, thank you so much for sharing some of your wisdom here with the folks who are viewing this. Just to recap, we looked at boundary claims and trespass from extensions and fences. So what we looked at was, what are the things that you need to have in place before you think about making a claim. And then the second thing is, what are the important facts that you have to support your claim. Thirdly, we looked at what's the procedure of how a claim is started or defended. And then finally, we looked at what happens when a claim moves to court and what are the timescales that are involved in that. Would you like to have any words to sort of cover anything that I've missed on this topic?
I think one of the issues that also arise with boundary disputes is a principle called adverse possession. So basically, it's known commonly as squatters' rights. So sometimes a boundary is not always easily ascertained, and someone says to me, well, as the client, I've been using, this has been the boundary for 10, 15 years, or it's been for 15, 20 years, the position. If that is the case, that brings in slightly different arguments from the physical position of the boundary. Because if someone's been, if a boundary's been treated or land's been treated as belonging to yourself for, say, 15, 20 years, or sometimes even longer, there are some arguments that we can bring in to say that the law actually has granted you that land because you've been using it for a considerable period of time. It's known as adverse possession, but it's quite technical, so we would be looking at that as well to try and bolster up the arguments as to where the boundary is, because the boundary could have changed because both parties, both our client and the neighbour, have been using the land in a certain way, and they've agreed, or they know that the neighbour has, he's used the land, he's treated it as his own. Therefore, he may already have acquired rights outside the legal position, in the deeds.
I suppose that's one more reason why you need to sort these out at the earliest, so that you can close issues like this well in advance.
Well, I think if you're going to, for example, if you're going to argue about adverse possession or some form of rights that you've acquired over a long period of time, you need to raise it right at the beginning. Hence, the fact that I'm saying that when I write this initial letter, I put in all the arguments right at the beginning, so that everyone understands exactly what the client's position is. Yeah.
Wonderful. Thanks so much for joining us today, Saul, and sharing your expertise in this subject matter. Folks, for those of you who are watching us, Saul Marine is the principal solicitor at Saul Marine and Co. Solicitors. They're based in Mill Hill in London. Feel free to reach out to Saul at his website, which is www.saulmarine.com. And my name is Nishit from Strategic Web Success, and you're watching a client spotlight and featuring Saul from Saul Marine and Co. Solicitors. Saul, thank you so much once again for joining us, and we look forward to having you on another segment soon.
Okay, thank you very much, Nishin. Okay.
Bye-bye for now.
Bye.